Can you appeal an arbitration award? Imagine settling a dispute and thinking it's over, only to wonder if you can challenge that decision later. That's what we're exploring today. Can you appeal an arbitration award? Let's find out. Arbitration is a way for two parties to resolve disputes outside of court. Instead of going to a judge, they choose an arbitrator or a panel to decide. Once the arbitrator makes a decision, it's called an arbitration award. Usually, this award is final and binding, meaning you can't just ask for a do-over. But there are exceptions. You can appeal an arbitration award, but only if both parties agreed to do so beforehand. Sometimes, the arbitration agreement includes a clause that allows for an appeal process. Some arbitration providers, like the American Arbitration Association or the International Chamber of Commerce, offer special rules for appeals. These rules let parties challenge the award on specific grounds. Appeals are generally limited to certain issues. For example, if the arbitrator made a clear legal mistake or based their decision on incorrect facts, an appeal might be possible. Also, if the arbitrator exceeded their authority or ignored the rules, that could be grounds for appeal. But appeals don't usually involve rehearing all the evidence. Instead, the appellate panel reviews the original record and looks for legal errors or serious procedural mistakes. To start an appeal, you typically have to act quickly. The rules often specify a deadline of around 14 to 30 days after you receive the award. You need to submit a written notice explaining why you believe the award should be challenged, along with relevant parts of the record. The appellate panel then reviews the case and can decide to affirm, modify, or reverse the original decision. They cannot send it back to the arbitrator for a new hearing. If no appeal process is included in the arbitration agreement, your only option is to seek judicial review in court. Courts are very cautious about overturning arbitration awards. They usually only do so if there was fraud, corruption, bias, or if the arbitrator acted outside their authority. Courts do not re-examine the merits of the case but focus on whether the arbitration process was fair. For businesses, it's smart to think about including an appellate clause in the arbitration agreement. This can give you a chance to correct serious errors without going to court. When choosing arbitration rules, check if they support appeals and understand what's needed to file one. Remember, the goal of arbitration is often finality, but having a limited appeal option can provide extra reassurance in complex disputes. In summary, while arbitration awards are mostly final, parties can sometimes appeal if they have agreed to it in advance or if the arbitration provider's rules allow for it. Without that agreement, the chance to challenge an award is very narrow and usually limited to specific legal issues.